Ms. Hackle,
Hi. Hello. The authorized representative for Hackle is here.
please turn your camera on, please.
Okay, I have to access it, so it might kick me out. So I'm gonna do it now.
That's fine.
Okay.
I know I denied the motion to set aside the default judgment back on August 21st. Defendant failed to appear.
Correct.
Defendant's motion to seek leave of court is denied.
We're showing a current, although this is a termination of tenancy for failure to recertify, we show a balance of in excess of $12,000.
Ms. Hackle, state your name for the record.
I am the authorized representative for Alicia Hackle.
I don't see your face. I'm sorry. I see your hat. Let me see your face.
Oh, okay, I'm here.
The camera's pointing at the top of your head. I can't see your face. All right. Mr. Hu, go ahead.
Yeah, thank you, Your Honor. A judgment was entered, a motion was denied, trying to set aside the judgment. Plaintiff is seeking a order of eviction for termination of tenancy. No payment has been made since March of 2024. We would ask that a writ be issued.
So the writ will issue and execute immediately.
Thank you, Your Honor.
I would like to say there's been a defective order of process. I never received a motion for today.
Well, if you were more than just the authorized representative of the freshly evicted tards, then you'd probably understand that at this point in the trial, requesting a writ of eviction is more procedural and doesn't require a motion, not to mention. The judge already said that you've already defaulted due to you missing multiple previous hearings, and he's already denied your motion to set aside the default.
Ma'am, what's your name? You said you're representative for Alicia Hackle.
Yeah.
What's your name?
I never received the order of process for court today. I went down to the court today, and she gave me the documents for court today. There's also isn't a sign off by a judge on the document that she explained to me that the judge didn't even sign the documents. I also never received a motion in the mail.
Well, this is an application. There is an application for eviction.
Yeah, there's an issuance for a writ here. I've actually never received that so that I could formally respond to it.
All right, so let me make a record. Give me 1 second.
Yeah, there should be some proof of service in the files for the case.
Well, hold on 1 second. 1 second. You were served with the summons and complaint. It was posted on the address by Chief Officer, Court Officer Juan Polanco. I believe he did it on July 20th, 2024. And then there was a default judgment entered against you by Judge Goubeau on July 31st, 2024. I believe you failed to appear. You didn't appear to that. And so that's how we get here now. Then you filed a motion to set aside the default judgment. Hold on 1 second. And you did not appear to the default judgment. So yeah, the writ in issue. So you've been advised of court and you failed to appear twice. Like I'm not understanding what's going on.
Actually,
so the writ,
all my documents. I've given all my documents. There was a judgment issued against me. And it was denied, but and then after that I hadn't received anything back for the case until I'm in court today about something that I had gotten no prior documents before I came to court today. I literally didn't receive any motion for issuance for a writ until today when I went to the court to get the papers. I didn't receive this by mail at all, so that I would have been able to respond to it before now.
Your Honor,
I have not missed any court dates.
Your Honor, I heard your ruling. Thank you very much.
All right. Thank you. We're all set.
Have a good day.
You too. Thank you. You got to move out, Ms. Hackle. It's just that simple. Sorry.
I'm not, because this is a common sovereign citizen tactic where they move into a place established residency and then refuse to pay any bills or rent, because the landlord contracted with the straw man and not the living being that actually occupies the domicile. So now we head to our second hearing, which is a follow-up to a sovereign citizen that I previously covered.
So is that Mr. Myrick?
Yes, sir.
Okay. So Mr. Myrick, good morning. It's I've got this set for a pretrial. Now I have a note here that said that you were not interested in court-appointed counsel, which is fine. So basically at this point in time, it's a pretrial. So I would set you up with a breakout room with the prosecutor to see, what their, if they have any offers or what their story is. I just want to make sure when you go in there, like you don't have an attorney with you and they're the attorney on the other side. They may give you an offer that you like, and that's fine. But I just want to make sure that that at any point in time, if you don't like the way the conversation is heading, if you change your mind and you do want to come back and ask for an attorney, just come back and let me know. Okay.
Okay. Before I get into the breakout room, Your Honor, I do want to address we are in the pretrial stage, and in the arraignment stage, I was entered a plea involuntarily. So I would love to have an ample amount of time to draw a meaningful defense. If anything, there was some questionable things that the last judge mentioned that I haven't found at all as far as a statutory jurisdiction. But I would like to have time to draw a meaningful defense as well.
Okay, so do you not want to meet with the prosecutor then?
Well, I don't think it's completely prudent right now, simply because we haven't technically went past the arraignment stage of this process. I feel as if my due process has been violated. Fifth and 14th Amendment. I didn't enter a plea, and here we are in pretrial. So I would like to kind of digress a little bit and have at least enough time to develop a meaningful defense.
Okay, I guess I'm a little confused. So you had an arraignment date, and
Yes.
at that arraignment date, did you refuse to enter? Did you refuse to enter a plea? Because that's the time where a plea of some sort has to be entered. So at that point in time, did you, of your own volition, say, I'm not saying anything at all?
Well, that wasn't totally the case, but I didn't have understanding of what court I was in, and I didn't understand if it was a criminal jurisdiction, civil jurisdiction, and based on the at least the federal laws for sure. We didn't come up.
Yeah, but you're not coming to an understanding about law with a judge is like Einstein not coming to an understanding about the fabric of space-time with a 3-year-old.
Okay, so were you in? So just so I understand, were you in custody at the time you were arraigned? Were you in custody?
No, sir.
Okay, so how did you know how to even zoom in and get here?
Say that again, Your Honor.
How did you know? Like for the arraignment, like oftentimes when there's an arraignment, that happens when someone's been arrested and they're sitting in custody, okay, or if they've received a ticket or some sort of notification. So you just said to me that you didn't even know what court you were in. So I just want to know, like, how did you know how to get here? How did you know how to zoom in? Because the Zoom information contains all of our like what court it is, what magistrate, like all of that's contained in there. So I just how did you know otherwise?
No, I did receive a ticket, and I got notice. But what my issue was appearing here on special appearance today, and I needed to get understanding of what jurisdiction I was in.
Okay. All right. So because I definitely want to make sure that people know where they're supposed to be. So I think I'm looking at the same ticket that you had. So it says on the ticket, 44th District Court, Royal Oak, And then the court address is on there. And then you said that you received notice. So the notice that went out, it would have had the Zoom instructions. Again, Mr. Myrick, as you can imagine, we are, I'm always very concerned in making sure people have the proper notification and all that. So it does appear that, I mean, you're here a second time. The only thing that I was, now looking at the file here, you were ordered to post a bond and you didn't. Now, that was, I'm reading the notes here. It says there was a bond of 1,000 cash surety, no 10%. So $1,000 bond was expected to be paid within 48 hours. Now, Mr. Meyer, we're here today. You showed up on time. So one of the reasons that a bond is ordered is, one, for the safety of the community, and two, to a secure appearance. Well, you come here a second time, and so I am very comfortable that you are going to continue to show up. So I, at the very least, for you, Mr. Myrick, today, as long as you continue to abide by the expectation that you'll show up, and you have twice now, I'm going to actually amend that bond. So even though you were supposed to do it within 40 hours and you didn't, okay, the fact that you showed up here again, at least to me, is enough evidence to suggest that I can count on your appearance going forward. So
the only issue I have right here is that Judge Minicki wasn't present during the arraignment and doesn't understand exactly why a bond was set in the first place. But if you'll watch my video, you'll see that the bond was set to ensure his future appearances, because this jackass doesn't think that any court has any jurisdiction over him. But in the grander scheme of things, and despite his delusional jurisdictional beliefs, he did show up to court. So why don't have a problem with him and his cognitive dissonance getting a PR on today?
And what I'm ultimately asking, Your Honor, is that if I can have more time to, I don't have any discovery. I don't have what I need to assess to move forward. So if I can have more time,
I have no problem adjourning the pretrial so that you could do some more information gathering. Just to let you know, Mr. Myrick, again, like our court, as you can imagine, with 696-75 Woodward, we have a lot of traffic misdemeanors that come through this court. And one of our signature programs that we've been doing for the last 8 years is, trying to really help people, because I would imagine that you pay attention to the challenges of the Metro Detroit area and public transportation issues and people's ability to get around, and how many people over time have got themselves in the cycle of they have to drive, but they pick up a ticket and they can't pay that ticket, so the license gets suspended and they get stuck in the cycle forever and ever and ever. Okay. Well, in our Operation Drive program, what we've done over the last 8 to 10 years, we're keeping stats since March of 2016. So in the last 9 years, we're over 1,700 licenses restored. So that's something that we try to do, is make sure that we inform, educate, get people the information that they need, which, Mr. Myrick, you could probably imagine, for years and years, the court system hasn't been great about letting people know even where to start, how to get their license. So in the meantime, while you're doing your investigation, I at least want to let you know what's on your record so that you can at least know, because some people don't even know where to start, how to go, or what to do. And the law has changed in a significant way. It used to be that every single little ticket that you'd get would suspend your license. Now it's only a couple tickets here and there that do that. So
I'm very honored, Your Honor, to be in your courtroom. I think you're the one that I've heard so much good news about, goodwill and good-hearted judge that assists the public, to opposed to the opposite. So I truly appreciate your efforts here. Thank you.
You can lay off the glazing mic. You still have a long way to go, because while Judge Minicki is a lot calmer and does put up with a lot more nonsense in his court, he does take his Operation Drive program very seriously, and if you do not, then he'll have no problem throwing your traveling ass in jail. So at this point, they begin calculating how much he has to pay to get back into good standing with the Secretary of State so that he can get his license back, and just look at the expression. on his face when he realizes that he can drop all this sovereign citizen and get back to being a positively contributing member of society for about $50.
Because, Judge, you're thinking it's an NPOI?
Yeah, it should be an MPOI.
All right. Because there
No
are
proof- no
three
proof
tickets, all of
insurance.
which are showing 45s. So let me-
Really?
Yeah. So let me look at the second one. Sorry, it's taking so long.
That's all right. That'd be great
All right.
news because that'd be just $45.
No proof of insurance. This one was a default judgment. It is showing $45. But it is showing a bond that you posted, sir, back in 2009 of $398. I think they took that, so perhaps they applied it to that fee, and they just want the 45. That may be the answer on that one.
Okay. So best case scenario, they'll let you just pay the 45. Okay. Worst case scenario, they'll want the $45 on each of the old tickets. So 135. So best case scenario, 45, worst case scenario, 135. But that's Allen Park.
Wow, that's great.
And that's 24th District Court, sir, if you're looking it up.
24th District.
And it's interesting because these are very old cases, but the close date on the third ticket is 2017. And now I'm getting error readings. So, but there's just 3. Looks like you had your bond taken on the no proof because perhaps you didn't go back, and that may satisfy that.
All right. So Mr. Myrick, so here's what we're going to do. I'm going to bump this out a couple weeks. You get to work chopping away at that kind of stuff. But I will say this. I only want to bump it out a couple weeks because if you get those things done, all right, I want you to come back and see me. We'll be able to run a new driving record. We'll see if by doing that, all right, that they follow through and let the Secretary of State know. Because if they take your money and they don't let the Secretary of State know, then the suspensions remain. And then we can even contact the Secretary of State and just make sure that they know, like, oh, by the way, he paid those.
Right.
And then when you come back here, you know, you can give me an update. But just know, if you've paid those 2 tickets, you should be able to go into the Secretary of State and pay the reinstatement fee and go from there. So what do you think? A couple weeks?
Safely to say, I would say 30 days. If I can have the grace.
No problem. No problem.
Thank you, Your Honor. I appreciate you dearly too. Thank you very much.
You're welcome. All right, so we'll adjourn this 4 weeks, and we'll send notice again. And then just do me a favor, Mr. Myrick, if you run into issues, I'm gonna send you our direct line here at the court.
Thank you very much, Your Honor.
And for example, if you do decide, if you're running into issues, I certainly can connect with Mr. Angot, Ms. Chappelli there. Mr. Angot's our MIDC coordinator. I know that you initially were not inclined to go with assigned counsel, but what Ms. Chappelli's doing today is exactly what would be done. So if you just reach out to us, let us know, like if you're running into brick walls and you say, like, I would like an attorney attached to this case, then
you know, for being such tyrants, the people of the court sure do seem to help the common man out a lot, which is ultimately the goal of this channel, as much as I like laughing at anti-American in court who don't believe laws apply to them, but absolutely apply to you. And the end game is to keep other people from falling down this rabbit hole as well and ruining their lives too, like the next guy who gets absolutely destroyed by Judge Colin Hunter. And what's funny about this hearing is that the sovereign citizen really only says about 4 things. It's just so glorious that I had to include
Court calls People versus Ryan John Hart, file 24-4935FH. Your Honor, Ryan Ziegler on behalf of the people.
Thomas Seeger appearing on behalf of Mr. Hart.
I have somebody in my hearing room listed as Ryan Hart. State your name for the record, please.
My name is Ryan John Family Hart.
I don't have anyone on my docket listed as Ryan John Family of Hart. I have an individual listed as Ryan John Hart. That's either you or it's not. You get to tell me whether or not that's your name. If it's not, then I need to call a different matter and bring somebody else into my hearing room.
Your Honor, I'm the representative of that entity, yes.
That's not an answer, sir. Your name is either Ryan John Hart, in which case you're invited to participate in the proceeding today as Ryan John Hart, or you're not Ryan John Hart, in which case I have no use for you to be in this hearing today. So tell me your name so that I can determine whether or not you're the proper person to be called in this case.
My name is Ryan John Hart. May I ask a question?
No, especially since you've already demonstrated your propensity to around in court, and this judge has no problem helping you find out.
No, you may not. Mr. Hart, this is not a complicated process, and this process does not get less uncomplicated. When I call a case, I start by identifying the parties that are to the case. When I'm confident I have the correct parties to the case, I proceed then and decide how to go forward. In this case, your difficulty, and I think intentional difficulty, is affecting the ability of the court to be able to proceed and to conduct its business. That's relevant to a lot of points, but most importantly, it's relevant to a pending motion that your attorney filed, presumably on your behalf, but I sense that it's not only on your behalf, it's also on your attorney's behalf. And so we're going to take up that motion. But your difficulty in basic things like telling me whether or not you're the party to a case is thwarting the court's ability to timely get its business done. I'm turning to the motion now that's before the court today, which is a motion to have attorney withdraw and to have you represent yourself, Mr. Hart. The court does not find that motion to be well placed, and I'm not going to prevent it. And the reason is there are several steps that need to be taken in order for you to be able to assert your right to represent yourself. First and foremost, I must find that your assertion of that right is unequivocal. I don't have that. What I have is your attorney's motion. And I recall very clearly and plainly the last couple of hearings that we've had. A couple of hearings ago, I had findings that I made based upon a competency and criminal responsibility examination. You were found both competent and criminally responsible by the court after assistance from the Center for Forensic Psychiatry and after an in-depth intervention and interview by them. I made the findings, your attorney agreed with them, and the prosecutor agreed. I have not once heard you make any type of unequivocal request at all. What I instead heard when I consider whether or not there's an unequivocal request for you to represent yourself is your attorney explained to me, I think this was 2 or 3 hearings ago now, that he was somewhat conflicted. And these are not his exact words, but this is what I recall from it. He was somewhat conflicted. You had wanted him to file various different motions, which the attorney did not find were supported by law. And the communication that I had in response to Mr. Seeger, again, was some version of this. I told Mr. Seeger that as the attorney, he and he alone chooses which motions are to be filed and which are supportable by fact or by existing case law or by the extension of existing case law. If he can't make those arguments that are good faith supported by law or an extension for the law, then he's not permitted to file the motions. It was at that point that Mr. Seeger then suggested that another solve for him could be that you could represent yourself. In other words, the implication that what Mr. Seeger was making is that if you were representing yourself, you would not be constrained in the way that he is. It would allow you to file whatever frivolous motions, I'm using that word, Mr. Seeger.
Oh no, Judge, you nailed it, frivolous. Unintelligible and regurgitative are all synonymous with sovereign citizen motions.
Whatever frivolous motions you wanted to. And so the request to have you represent yourself as made through your attorney is not found, number one, by the court to be unequivocal in any way. Number two, I would have to go through with you and be confident that you understood the maximum penalties associated with the crimes. I have every reason to believe that you understand the maximum penalties, but I have every reason to believe that if you and I had a discussion about what those maximum penalties were, you would express confusion and you would not express a knowing, confident, and voluntary understanding of those things. And so I'm not yet even going to get to that second step. I also, of course, would have to, under People versus Anderson, the binding Michigan Supreme Court case regarding waiver of constitutional right to represent yourself, I would have to make specific other findings. And those findings specifically are that I would have to determine after a conversation with you that you acting as your own attorney would not disrupt or unduly convenience or burden the court in the administration of the court's business. What is plain, obvious, and unarguable in over the last 2 or 3 hearings is that if you were permitted to represent yourself, you would make the court's administration of justice difficult, you would delay matters, you would be disruptive, and your representation, therefore, of yourself would be unduly inconvenient to the court and the court's operation of its business. For that reason, even if I found that you otherwise made an unequivocal request, which you haven't, even if I found that you clearly understood and you expressed your waiver knowingly, intelligently, and voluntarily, the court would still not grant your request through your attorney to represent yourself under specific circumstances here. It's my firm finding based upon the background that I'm aware of that to allow you to do so would only encourage you to file what are very spurious and frivolous motions. It would waste the court's time, it would waste the prosecutor's time. And although it would waste Mr. Seeger's time to have him remain on, the court also notes that even if there is good cause for Mr. Seeger to withdraw, the Michigan rules of professional conduct allow the court to continue an attorney's appearance and order that an attorney continue on a case even when there's good cause to withdraw. And so I choose to exercise the discretion provided to me under those Michigan rules of professional conduct and the Michigan court rules and Michigan case law in denying any request to have you represent yourself. You are and will remain represented by Mr. Seeger until further order of the court. Mr. Seeger, did you need then some time to discuss the effect of that ruling with Mr. Hart before I decide how this case needs to resolve?
I do,
by way
Your
of trial.
Honor. Additionally, Your Honor,
Your Honor,
amended offer.
Your Honor, I have something to say. May I speak?
Mr. Hart, you don't get to decide
Your Honor,
when
let
things
me
are said.
speak. Let the
That's
record
again
show
part of the
that
issue.
the judge has not let me speak at all in more than three.
Mr. Hart, this will not be an argument. This case will not proceed by me talking over you or you talking over me. Court proceedings by law and by procedure, Mr. Hart, are to be ordered. And they're to be in a specific order, and that order is dictated by the trial court judge. That's me. It's not dictated by an individual who's charged with criminal offenses, you. And so I'm going to exercise my discretion to control those proceedings. You right now, Mr. Hart, are free on bond. I don't particularly have any care as to whether or not you're free on bond or whether or not you sit next door, except to this point.
And that, my friends, is how you shut down a crayon muncher. You just mute him and remind him that while his freedom is an afterthought, it still hinges on his ability to act like an adult in court.
For today, I'm going to expect that you disagree with my decision on your motion to have you represent yourself. I'm going to therefore excuse any further appearance of you for purposes of today's hearing and today's hearing only. I'm going to set this matter for a new hearing after I hear from your attorney and from the prosecutor. That new hearing is going to be set in person. The reason I choose in my discretion to set it in person is because if you're disruptive or unduly burdensome to the court at the next hearing in person, I'm going to view it as a violation of your bond conditions. And if I view it as a violation of your bond conditions, you're going to be subject to the contempt powers of the court, which includes me revoking your bond and you sitting next door. Because if I have your bond revoked and you're sitting next door, I'll know that Mr. Seeger can locate you and communicate with you. And if you have your bond revoked, I'll know that I'll be able to better control the situation than I can over an electronic communication like we're doing now. Because as you've demonstrated, the only way I can control the proceedings right now is to mute you so that you can't speak over me. That's not an effective way of running a courtroom, but it's the only way that I'm given your attitude, experiences, and your frustration. Mr. Seeger, did you wish to make a responsive record?
No, Your Honor, I do understand the court's ruling and I clearly will abide by it. Be that as it may, Your Honor, and I will discuss this with Mr. Hart. There was an amended offer that was extended.
Can you please speak up so that Mr. Hart can clearly?
Sure, Your Honor. There was an amended offer that was extended, which is much more favorable than the previous offer. I will discuss it with him. He can determine how he wishes to proceed.
All right. Did you want to, for purpose of the record, state that offer on the record?
Your Honor, my understanding is that he could plead to one count of attempted resisting and obstructing, which would be a misdemeanor in lieu of dismissal of the attendant charge together with the habitual offender notice.
What was the habitual offender notice that was charged?
It was I don't have it in front of me, Your Honor, because I just had the motion.
Your Honor, he's subject to a habitual for, I believe it's on the information.
And I just didn't have the file in front of me, but do you disagree with that, Mr. Seeger?
No, Your Honor.
All right. So, Mr. Hart, it's very important that you not only hear the offer that's been made as an offer to an attempted resist and obstruct charge for dismissal of the existing charge as well as a habitual fourth, but it's fundamentally even more important that you talk to Mr. Seeger about that. He can give you advice. You ultimately get to decide how to proceed, and it does not matter to me how you proceed, so long as you proceed with the understanding that court procedures require structure, and that structure will be followed by you and by anyone else that's in this courtroom, or there will be alternative options considered by the court. Mr. Ziegler, anything further on any of that the people would like to offer?
No, Your Honor.
No, sir.
All right, the court will set this matter for a status conference next month. I will require that everyone in this matter be in person for the reasons I've already explained. Mr. Hart, you're free to sign off now. I expect you'll talk with your attorney and be here in person next month. You'll get a notice in the mail.
Just look at that face. That face is the face of a 50-year-old petulant toddler who needs a safety binky before he starts bawling. All right, guys, that's the end of the video. If you like the video, hit the like button. If you disliked it, hit the dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content.